the housekeeping stuff while we're waiting. As we have discussed over the past 6 years, if this is general legal information we're going to talk about today, we are not giving you legal advice. If you need legal advice, please talk to your community association counsel, or if you're an owner, to your own counsel. And you may notice that we say a couple times, this is veering towards legal advice. We're going to give you general information, so just keep that in mind. And similarly, all the chat function we have enabled, just make sure that you're not requesting legal advice in there. And if there's a question there we can't answer, we will let you know. We're happy to answer any requests for clarification, or it's possible we may have some time today to answer additional questions. So if you had some that you didn't get to us ahead of time, please go ahead and throw those into the chat, and we'll do our best to get those answered. If you can keep yourself muted today, that would greatly help with the background noise for us. But if you need clarification on a question, especially if you've put one in the chat and we're not quite sure what you're asking, feel free to unmute yourself to respond to that question. I'm trying to think if there's anything else we need to cover. I don't think we put the note into the chat today. Let me do that. Sorry, everyone. My computer's acting crazy. Okay, so I think with that said, Jennifer, anything you want to add today to the introduction?
No, I think you've covered it.
Great, let's get started. The first question is, if a topic on the meeting agenda is stated for discussion, and I'm thinking slated for discussion, is it necessary to state in the agenda that the item will be or may be voted on at that time, meaning in the meeting? For example, at a regular meeting, there was an item that was landscaping. At the conclusion of discussion, there was a vote taken for action on that topic. Would it have been necessary to state in the agenda that a vote would or might be taken when it wasn't necessarily certain that that was going to happen? I will direct you to, we've had lots of conversations over the last 6 years about agendas and minutes, and feel free to you can search those terms on our YouTube channel if you have further questions about agendas and minutes. For guidance on this, I look to WUCIOA 649445. The only requirement there is that an agenda of the meeting be sent ahead of with the meeting notice, with all the appropriate deadlines and things like that. There's no requirement, excuse me, in the statute or any of the other statutes that says what needs to be in that agenda, or that there need to be motions included in that agenda. For example, a motion could be made at any time, even if it wasn't noted on the agenda that there was a motion to be made. So I think the answer is no, there does not need to be an indication that a motion will be or could be made, merely that the topic is slated for discussion. It's possible, for example, that a board member might say, I don't have enough information, let's pen this over to the next meeting. And then there might not be a motion at that particular meeting. It might just ride the agenda to the next time. Or a board member could decide that it was time to make a motion, and the motion may be approved or not at that time. But I think the basic answer is you don't have to indicate whether there's going to be a motion, but you do need to be clear about what items are going to be discussed at that meeting on the agenda that's sent out to everyone in advance of the meeting. Anything you want to add, Jennifer?
No, there's a question in the chat, and I think I'm just going to cover that one really quick. My board has strategic planning meetings. Are these still meetings homeowners should be invited to attend? It is listed on the meeting minutes. So we've covered this, I don't know how many times over the past few years, especially more heavily in the last, I want to say, quarter of last year. So yes, anytime the board is getting together to discuss association business, it is a meeting. It needs to be properly noticed, and owners need to be able to attend to view the proceedings. Did you have anything that you wanted to add to that, Lisa?
Jennifer, do you think that they also need to provide an option for homeowner comment and things like that at that kind of a meeting where it's a strategic or a planning meeting? I don't necessarily think so.
649445 just states board meeting. So board meeting is a board meeting is a board meeting. So yeah, I would say that it needs to be treated as a meeting, even if it's just a planning session and no votes are taken. It's still a meeting where the board is discussing association business, which needs to be open to the owners to view. So, did you want to add anything
Nope,
else?
go for it. Go
Okay.
for next question.
The next question is, I have an association that had planned to get an HOA loan and the special assessment for it has begun. Many more owners than expected paid their special assessment in full upfront, and only a few will pay monthly with interest toward the loan. The number of owners paying monthly has been reduced to a point where where there may no longer be a need for a loan, and existing reserves can make up the difference. If there's no longer a loan, do the monthly special assessment payments that will run for 10 years still include the interest portion for the loan as was ratified? Or do we adjust the monthly payments to exclude the loan interest? So this is a pretty specific situation, and you should probably contact your association counsel. We can't give legal advice in this forum. But generally speaking, the association should comply with the terms of the special assessment that was approved by the owners at the ratification meeting. If there's a change needed, it likely would make sense to have a new ratification meeting to update the terms of the assessment. Lisa, did you have anything to add to that? I'm
Sorry, I was having some issues with my volume. Hopefully, I was having a concern about the loudness of my microphone. Hopefully, that has been adjusted. Does that sound better to you, Jennifer?
Yeah, I can hear
Okay,
you much better.
perfect. Apologies. No, I have nothing to add to that question. I will move on to the next. The next question is, we're interested in posting some no trespassing signs, and we're inquiring to see if that type of sign must reference any Seattle ordinances or Washington State RCW. I thought there could be a chance that Condo Law had prepared documentation about this in a weekly webinar or online. I'm not aware that we have prepared anything like this or about this topic. And to my knowledge, there is no requirement to put any statute or any local ordinance on a no trespassing sign. This is not a sign that is like a no towing sign, or excuse me, a tow zone sign where you do have to put the statutory authority and notice to the person who's parking there that their vehicle may be towed. So this is a different situation than that. I believe that your only obligation is to post the signs that this is private property and no trespassing. And then if someone ignores the signs, you may be able to involve law enforcement to assist you in removing that person. I think if you have specific questions about these types of signs, ask your attorney. They may be able to assist you in drafting a memo or providing you guidance on this. You could also contact your insurance agent. They may have some direction for you or some advice for you related to your insurance coverage. That's certainly a place to start. But just as far as I'm aware, there's not a requirement. You could Google around and see if your specific municipality may have something. But as far as I know, generally speaking, there isn't a requirement like there is with towing to post a specific statutory authority on your no trespassing signs. Anything you want to add to that, Jennifer?
No, I think you covered it. So our next question is, all started with 275 homes HOA. As a large community with very particular demographics, they have a massive amount of violations and architectural control requests. Is it a must to vote for violations and ACC in an open board meeting? Can you offer some sort of outline of logistics on how to navigate the practicality without violating the law? So it part of it depends on how you handle or who makes the ultimate decision. So the way 6490-445 reads is that if there is a committee that exercises board authority, they must follow the same regulations and rules as board meetings. So open meetings, time for owners to comment, etc. So it's probably reasonable for the board to have a policy on how these are handled. So the board has the ultimate decision-making authority on whether or not something is a violation. So they can have a policy that for potentially for initial violations, warning notices may be sent or what have you. Um, the question becomes what happens when an owner pushes back, number one, and number two, is the board exercising their authority properly? So the answer is probably in the association's governing documents. It is in how you treat these. You can just have a quick, if you have a committee that does the investigation and takes the initial reports and then gives the board all of the information, and then the board is just voting whether or not something is a violation and to follow the enforcement policy, that can be handled almost as a consent agenda. But again, who ultimately is making the decision on whether or not something's a violation? So if a committee is doing it and then the board, and nothing goes to the board, then the committee must be following the same procedures as the board. If the board is making all of the decisions, there are ways to take some of the onus off the board and make things move a little quicker, but it really depends on the circumstances. So if the question is more to do of what happens when an owner objects and requests a hearing, and the determination is on the board for the hearing, a motion in the regular meeting is appropriate. A motion, and it can be just as simple as motion made to enforce violations against a certain account, a certain address. It doesn't have to be the owner's name. So this is something that you should probably speak with the association's attorney about to come up with a procedure that makes sense for the community, but also ensures that the board is following their statutory duty of care and following the statute. Lisa, do you have anything to add to that?
I guess I would just add that I know that some boards are concerned about privacy of owners, things like that, and they are tempted to move all this stuff to executive session. And we've talked a lot about in previous meetings about what's appropriate in executive session. And while it might be appropriate to generally discuss association business that is delineated in the statute, the actual motion, as Jennifer said, on how you're going to handle a violation or even a collections action or anything like that, it does need to be in the regular session minutes when the termination has happened. But nothing else to add to that.
That wasn't my question, but I have a question on it. Can I ask
Sure,
that now?
go ahead.
Okay. Uh, so if associations have adopted rules and a fine policy, and they have management, is WUCIOA dictating that boards need to approve the issuance of every violation notice? Or
So
is this in the context of like a dispute?
no. And the answer is that the board has a statutory duty of care in all community association statutes. For WUCIOA at 6490-410, I think subsection 2. And then also in the nonprofit corporation statutes. So this board has a duty of care to act reasonably, based on verifiable information and in the best interest of the association as a whole. So the board holds the authority to determine whether or not something is a violation of the governing documents. That particular authority could be delegated to the manager, but it needs to be explicitly delegated, not just, oh, the manager handles all of that. And then the board retains the authority to determine, okay, if there is if an owner wants a hearing and wants to contest a violation, the board should be the one to sit and determine whether or not that thing was a violation and or what should happen because of that violation. So some of the authority can be delegated, but it rests with the board.
Okay, but we're not needing board authorization to proceed with sort of normal notice on violation. We would still go through essentially the hearing process if somebody wanted to dispute their note that they received, in which case that would fall to the board to decide on.
I would be careful there, and depending on the circumstances, run the procedure by the association's attorney, because the board holds the ultimate authority to determine whether or not something is a violation. We have had situations where owners have called management companies about their neighbors to harass the neighbor, and the management company didn't do a proper investigation. That particular issue, the risk still lies with the board.
Is it a good practice in scenarios like, for example, parking is some of those things that are maybe a little bit more easily verifiable if we're as management receiving photographic evidence of the violation and following the written policies per their rules, and then obviously any disputes go back to the board? Like, would that still be a good practice?
We're getting a little too far into
Specific.
giving specific advice.
Yeah.
So contact the association's attorney. They can help give you the answers on what can and can't be done.
But I will say that in general, having a policy, the board could enact a policy that says that XYZ could be handled, by the manager or by a board delegate. And then, as Jennifer said, the ultimate question would come back to the board. But there, we do that in some kinds of collections things, right? If
Right.
an owner reaches X amount of delinquency, then the manager is able to send this on to, or whatever the issue is. So there could be a policy for that kind of thing.
Because of the changes per the statute, like a lot of associations already have written rules and procedures for violations. Is it advisable generally that we have, I guess, a rules revision to kind of include how the board wants quote unquote regular violations handled, and update like all of our association's rules in theory? Like, is that a best practice?
We can't really answer that question.
Yeah.
It's a little too specific. I'm sorry.
Right. No, that's okay. This is not an angle I had explored yet on this topic. So thank you guys for all your help.
No problem. This whole
No
the
worries.
new meeting stuff is definitely providing some challenges for all of us and figuring out how to navigate all of our work. So
Logistics. Yeah, it's crazy.
Well, we'll hopefully or probably be seeing some court cases, and then we can maybe have better answers for some of these questions. And I think we'll talk about that in a minute too, about what things mean in the context of meetings. The next question that I have on the questions list is, does an association need to give official notice when announcing a compliance inspection, sort of related to that question, or can this be done through an email to everyone? And I think the answer to your question is probably going to depend on your governing documents. Back to what we were just talking about. What is it? What is, if there's no reasonable time, or if there's no timeline or schedule, that there might be a reasonable expectation that notification is given. But if there is a policy that says you can't park here, I don't necessarily think that that notice needs to be sent to everyone that says, tomorrow we're going to go check on parking. I think, if there are rules in the community, I think there's an expectation that they're followed, related to compliance. If we're talking about, are you going into someone's unit and checking that they have a fire alarm, or that their flue has been cleaned, or what XYZ thing, then we're talking about something entirely differently. And obviously notice provisions or notice must be given before entering someone's unit. But if we're talking about someone driving around the community and seeing if homes are in compliance, I don't necessarily think you need to give notice of that type of an inspection. Again, if it's entering someone's home, that is an entirely different thing. You'll want to talk to your counsel about that. But I think if you have a specific question about something you're not sure about, I think that's a very a reasonable question to ask your association's counsel prior to doing any kind of inspection, but particularly if you need assistance with notice for entering someone's unit, talk to your attorney if you have questions about that. Anything you want to add, Jennifer?
Just briefly, a lot of people get hung up on expectation of privacy and owners complaining about you're invading my privacy when they get cited for a violation. So if something is open to view to just a general passerby, and this includes common elements in a condominium, even stacked units or what have you, it doesn't have to be available to the general public. As long as it's open to view by anyone passing by, there is no reasonable expectation of privacy. So you don't need to send out notice that, hey, the management company is going to do their quarterly inspection on between these dates. Make sure you get stuff picked up, what have you. You don't have to do that. So if you have to enter onto private property or a limited common element, so you need to go onto somebody's lot or onto a limited common element or into a unit, the rules are different. So contact your association attorney if you have to do that. But if it's just driving through the community, any area that is open to public view, you can just do that. You don't need to give any sort of notice for it. So our next question.
I was going to ask Jennifer, do you want me to cover this question?
Since you deal with collections, yes, please.
I've
already snagged one of yours later, so go ahead.
I just noticed what this topic was. The question is, after notices of delinquencies have been sent out to a condominium, what is the standard time frame for the attorney to take action and reach a conclusion on a foreclosure request by a condo board? The person says 3 months, 6 months. As Valerie often says, your mileage may vary. That's the best answer I can give, but I'll give you some more specifics. And the reason is this is a very hard question to answer. Every file is different. I'm just going to give you some kind of expectations, but depending on how the lawsuit goes, it could take shorter or longer than the estimates I'm going to give you. At the beginning, assuming that the referral that you hand your attorney is pretty complete, that they don't need any additional information, they've got everything they need to get a demand letter out. A demand letter can probably go out within a week or two. And then that demand letter usually has a 30-day response time. So we're talking probably about 6 weeks at that point. After that time, an attorney might recommend that a board review and vote on foreclosure. And that can take some time because, as we discussed, this all needs to happen at these kinds of things need to happen at a board meeting. So this just depends on when the next scheduled board meeting is, and assuming that the minutes provided are what the attorney needs to see, because the statute requires that the board make a motion and hold that vote on in their regular session. Then the attorney starts doing their due diligence, checking and making sure there aren't any risks to filing a foreclosure, getting a litigation guarantee, running skip traces on owners, and that can take some time, potentially up to a month, because it depends on what kind of a title situation we have, what the title company looks into, if there are questions, if the person is deceased. And once that happens and the attorney is able to file the lawsuit, this is where the estimates kind of go out the window. I'm going to say in a perfect world, it's probably less than 6 months or probably about 6 months, but someone is evading service, that adds 90 days. If someone files a response, that adds a lot of time. If there are other motions that need to happen and the court calendar is an issue, that can add some time. And assuming everything goes perfectly and we get this wrapped up and we get a judgment, which is the ultimate goal of a foreclosure lawsuit, it's a judgment against the unit for a decree of foreclosure, and it's a judgment against the owner for personal amounts, for personal money due against that owner. And then at that time, we need to go back to the board. Please vote and tell us, do you want us to garnish this person, or do you want us to ask the sheriff to set a sheriff sale? If it's a sheriff sale, that's another few months getting the sheriff, excuse me, getting the orders of sale issued by the court and having the sheriff set that sale. And then there's a 12-month redemption period. During that 12 months, the owner, whoever bought it at the sheriff's sale, the association or a third party, has the right to the unit as long as it's not the former owner living in there. So they could potentially rent it out or try and sell it subject to that redemption period. And then at the end of that 12 months, assuming that the former owner didn't pay the balance due at that time, the owner becomes the owner. So it's not a short process. I would say I couldn't give you a percentage of time that we get to the point of judgment or sale and then we get the whole amount paid off. I've had several go into redemption in the past couple of years. So even though we think that's the end, sometimes it's not the end at all. But oftentimes, even if we start a foreclosure, we often get to a point where someone does pay the balance, including the attorney fees off. So that's the very long answer to your question, but I'm going to say about a year for a general foreclosure just to get the lawsuit filed, the judgment entered, and the sheriff's sale set and accomplished. And that's in a pretty perfect world. Anything you want to add to that, Jennifer?
No, you've handled it.
Okay. I'll go on to the next one. This is a question about board emails. One of our board members recently asserted that all emails between board members must go to all board members. Otherwise, this board member says email conversations are considered secret meetings if they're not including everyone. They said that this board member said this violates the current RCWs. And the questioner asked, is this correct? I thought that under WUCIOA, emails can't be considered meetings, right? If all board members in our community are always CC'd on every email, then the email boxes will go wild. They'll be full of irrelevant information. It doesn't make sense if you've got maybe a committee of 2 board members who are working to look into a new software system or a new landscaper. Why would they need to loop in everybody else if they are the ones who are working on that one assigned job? And I will, my response to this kind of long question is, you're right. At this point, emails are no longer considered meetings unless the action taken is ministerial. And nobody knows what that means. We think it means, because it's an undefined topic in the statutes, we think it means kind of rote things. But in any event, most meetings are happening in person at a board meeting, and as the statute sets out, and as we talked about before, with proper notice, with owners in the room, with the agenda sent out. And so my position on this is that that is not a meeting having owners or having board members included on emails. The statute is referring to an email that is between all the board members where someone would have in the old times made a motion, and if assuming all of the board members were on the email and everyone voted unanimously, then the motion carried, and then that you just need to ratify it at the next meeting. That is essentially no longer happening because of this new open meeting requirement for all communities. I think as you said, it makes sense in some situations for not to have all of the board members on all of the emails. That would be a wild experience and a very full inbox. The whole point of assigning board members on certain tasks or on committees is that you don't need the full board to be involved in all of the action of the board. And the board meeting is the place to update everyone. The treasurer would come, at the board meeting and give an update on the treasurer's report, up on the budget. You may have another board member come and give an update on looking at the landscaping or replacing the floor mats in your entryway or whatever the thing is. But I think you're right. There isn't a restriction on quote unquote secret meetings. That's not a term in the statute. So I think you're right. I think this is sort of an old, this is a misunderstanding of what the statute says. It's impractical to include everyone on everything all the time unless there is a need to. But again, it's not a vote. You're not voting anymore by email. So these communications don't need to necessarily include everyone. The board is the board at a board meeting. Otherwise, they are other owners, just like everybody else, communicating with each other. And I don't think you're required to include everyone on all of those meetings. Did I miss anything, Jennifer?
I have to give a couple caveats here.
Yeah.
And part of that is because if an owner sues the association, board emails may become discoverable.
Correct.
So discovery is different than statutory requirements and record keeping. Be cautious in what you do via email. If the board is discussing association business and coming to a consensus and then just holding the vote at the meeting without having any discussion, that's a clear violation of the legislative intent behind 6490-445. So if you are discussing logistics, does anyone have anything to excuse me, add to the agenda? Or hey, you were given this topic to research and do. Are you ready to present it at the next board meeting? Stuff like that is probably okay, but just be very cautious in what you do and how you do it. This is new statute. There is no case law saying what you can and can't do. We just don't want any of our clients to be a test case. So we're going to be a lot more restrictive to ensure that you're not accidentally going against the legislative intent and suddenly have a lawsuit. And we do have at least one association in a lawsuit right now regarding association records and emails. So your mileage may vary, but treat email, text conversations, phone conversations cautiously when it involves association business.
I think your next question might fit really well with this.
I would not be. Oh, yes. Yeah, even more discussion on the open meetings. So our next question is the new law on open meetings states committees authorized to act for the board have to be open, but others don't. We have a board stating that because they approve the PO, I believe that's purchase order, that a committee isn't acting for the board, even though the only decision is accept the PO or not. This is for a gym committee buying new equipment, a social committee planning events, and even the hiring of designers and gardeners. Does approving the final budget with no input prior really fit the new law? It feels more like a rubber stamp. So if you have a committee that is given the authority to do a specific thing within a set guideline, say you have the landscaping committee, okay, the landscaping committee can review contracts for vendors up to X amount or have this amount in the budget for a particular contract, and anything else has to go to the board for review. The board has exercised their diligence and their duty in assigning association members to that committee and delegated funds for the committee to use, and then they don't need to do anything else. For a social committee, say you have an annual picnic that everybody is really excited about, and there's food trucks and vendors and all sorts of things, and the board gives the committee a budget that they have to remain in. The board doesn't need to exercise authority and approve every single contract as long as it remains within the budget. So this is a good way for the board to delegate authority to a committee to do work for the association, and then if there's a problem, it comes back to the board. So I would say it's fine. This would be typically we would recommend having a committee charter and the board putting guidelines on what can and can't be done with a particular budget for a committee. But it's up to each individual board how they want to exercise that authority. And typically and honestly, running an association is a full-time plus business. If you are self-managed, you have volunteer members having to live their lives, have their jobs if they have one, and also full-time plus running this corporation that manages property and buildings, etc. So a board delegating authority to a committee within specific parameters, that's perfectly within their statutory duty of care and their authority. Lisa, did you have anything to add to that?
Nope, I'll just go on to the next one. The question is, hi, I recall receiving a newsletter from a source that said the legislature just voted to change the audit requirement for homeowner associations that have a budget of $100,000 per year or more versus the $50,000 that it had been. I can't find the email to confirm this. Do you know if the law has officially changed and when it will be incorporated into 6490? So just kind of a quick reminder, this is a question about whether when an association is required to perform an annual audit. This is found under 649530 sub 2 for WUCIOA communities, and it requires that an association that has annual assessments of 50,000 or more need to be audited at least annually. And in the case of ones that have less, then the audit can be waived if the unit owners vote to do so. These provisions are slightly different in the other statutes. In 6434-372, it is about unit size. So if you have more than 50 units, those principles would apply. You have to have an annual audit, or the vote, if it's less than 50, the owners can vote not to. And then in 6438-045, which is the homeowner statute, it also discusses an audit with assessments of over 50,000. But the audit, there's different provisions for waiver of the audit. In those situations, it's if 67% of the votes cast by owners vote to waive the audit, then the audit can be waived. There was recently a new substitute bill, which has been signed by the governor. It's Substitute House Bill 2354, and that is an amendment to the WUCIOA statute. And that I have not read the entire bill yet, but that does increase the waiver threshold for WUCIOA communities to 100,000 instead of the 50,000 that I just mentioned. So I believe that is going into effect in June 2026, so coming really soon. And we will look into that. If there are more questions about that at a later time, we'll be able to research that a little more thoroughly and give you more information. But for what we know right now, that is going into effect in June, and it is Substitute House Bill 2354. And again, it's related just to the WUCIOA statutes. Anything you want to add to that, Jennifer?
Just a brief reminder, because we get questions on this all the time. For any community that was created after July 1st of 2018, you are a WUCIOA community. For communities formed before July 1st, 2018, you're under one of the other statutes. So unless you've adopted WUCIOA as your governing statute, most of WUCIOA does not apply to you. But we will have there'll be more later because we do have a question on this topic. But just remember that unless it's listed as a specific part of WUCIOA that applies to everyone, it only applies to WUCIOA communities.
Until 2028.
Yeah, until January 1st of 2028. So our next question, and it's the question I was thinking of. Okay, so the declaration of our condominium was recorded in 1978. We are governed by RCW 6432. Does any part of RCW 6434 apply to our condominium? Does any part of RCW 6490 WUCIOA apply to our condo? If so, where can we find a summary of what applies? Please advise. So any condominium from 1953 to July 1st of 1990 is under RCW 6432 unless you've adopted later statutes. So when 6432 is not a good statute, there are a lot of missing information and there are better statutes out there. So instead of just amending 6432 in 89, the legislature adopted 6434 to clean up some of those provisions and then made it effective July 1st of 1990. So under 6434010, I believe sub 1, it lists the particular provisions of 6434 that apply to Old Act condos. So, yes, in a nutshell, there are provisions of 6434 that apply to 6432 communities, but only for events after July 1st of 1990. So you can't go back to 64 or, in your case, 7980 and say, well, this violated statute. No, it didn't, because the statute didn't exist then. So 6434010 lists the particular statutes of 6434 that apply to all condominiums, no matter when they were formed. So when the legislature adopted 6490, they've moved where this statute is located. So it's now found under 6490-365. So, and it has a list of those particular provisions that apply to all communities. No matter when they were formed or if they're a condo co-op, what have you, this is what applies to you. And those include 6490-370, 6490-405, sub 1, B and C, 6490-445, that happened last year, 6490-480, sub 10, 6490-502, 513, 525, 545, 580. So basically provisions regarding meetings, budgets, electric vehicles, heat pumps. Some provisions the legislature has added to 6432 regarding records and other particular provisions, but these two statutes, 6434010 and 6490-365, list the statutes that apply to all communities. Lisa, did you have anything to add to that?
Nope, but I will give my plug that I give often is that you can Google this. Sometimes you can just say 6432, and 6490 or something like that, or do a search for terms in the statute to find it. But yeah, the bottom line is that there are WUCIOA is, as Jennifer's list indicated, is slowly encroaching and will quickly encroach on all of you soon. But the things that are really key, and we've talked about them a lot, are the meetings and the budgets for sure. Make sure you're familiar with those provisions. If you're a community that's not for every community, but for particularly ones who weren't formed after 2018. Okay, next question, and this is again right up my alley. The new late charge of $50 or 5%, is this effective when January 2026 changes? And can boards begin to use this new rate now? And I can give you an emphatic yes, this is effective, was effective as of January 1st, 2026. This has been added to all of the statutes. This, for people who aren't aware, is the collections provisions related to assessments that requires and affects all associations. It is, you can look for a specific language just as an example in 6490-485, subsection 20. And the same language is in the other statutes. And it limits what an association can charge for a single late fee until certain things happen or once things happen. And that single late fee is of no more than $50 or 5% of the amount of the unpaid assessment which triggered the fee, whichever's less. So if your late charge is $50, but your monthly assessment is a small enough amount that 5% would be a lot less than $50, you have to charge the 5% of your assessment. And there are steps and requirements in those statutes, which we have talked about several times. You can do a search on our YouTube channel for assessments and just look, late 2025, early 2026, and we've talked about those. It has to do with the notices that you send to your owner when they are first delinquent and the timing for those. So definitely familiarize yourself with that. And if you have specific questions about your notices or what you can charge an owner, talk to your association counsel. It may be that you need to update your collection policy to make sure that you are complying with that. It doesn't say you can't charge a $50 or $100 late charge at a later time, but there are that initial late charge starting January 2026 can be no more than $50 or 5% of the assessment amount that is delinquent. Anything you want to add to that, Jennifer?
No, I think you've covered it. And we may have time for one or two questions. So if you have a particular question that you would like us to see, please put that into the chat. If we don't get to it, we'll add it to the list for next week. So the next question is, can the resale certificate charges be increased now by the board automatically with notice? And we're not sure exactly what you're asking. If it's the total cost you can charge for a particular resale certificate, statute sets that limit at $275, and then an additional $100 if a second request is made within 6 months. Statute sets the amount for the resale certificate, so that's what you can charge by statute. We have had communities that try to add a little extra to that, and we don't recommend it because it's going against statute.
And I think, Jennifer, didn't they refine the statute a little bit too to make it pretty clear that the 275 needs to include any fees and other stuff?
And
Yeah.
yeah.
It's really 275.
Yeah, the legislature was very clear about that. So yeah. Did you have anything else you wanted to add to that one, Lisa?
No.
Okay, so our last question that we've prepared in advance, is there a dollar amount for an item to be deemed a capital expense? So no, there is no particular dollar amount that makes a particular expenditure a capital improvement or capital expense versus just maintenance. But there is a difference in how these two terms are used. So in most declarations, there's a section under the authority of the board where it talks about if the board makes a capital expenditure or capital improvement of a certain amount, you need a particular percentage of owners to approve it. And then if it's a higher amount, you need a supermajority of the owners to approve it. Now, and I just had to answer this question for one of our clients. So there are court cases reviewing this language. And what happened is that an association, two different associations and two different court of appeals did massive repair projects. And the materials used to repair the buildings were improvements over what was originally constructed. So owners failed to pay the special assessment and then challenged the assessment, went to court, and were arguing that the repair project was a capital improvement because they improved what was existing rather than just repairing what was existing. And the court found that no, even if you changed the materials used for a project to better comply with current building codes or because of better technology or what have you, it didn't really matter because you were still repairing what already existed. So if you are doing a repair project and are changing components or what have you because of better technology or something needs to be done to better prevent damage in the future, that's not a capital expenditure or capital improvement. That's just maintenance. A capital improvement or capital expenditure is for something that does not exist currently. So using the example of a community wanting to add a pool, that would be a capital improvement that would fall under the requirements of your governing documents for owner approval. Adding a surveillance system, what have you, if it doesn't already exist, it would be a capital improvement. If it already exists and you're just changing things to prevent damage or comply with code, etc., that's maintenance. And they're two completely different things, but they're often confused. Lisa, did you have anything that you wanted to add to that?
Nope, I didn't.
Okay, so going to the chat. Answered that one. Okay, so I believe the first question in the chat, why would we need to do an insurance deductible shifting amendment if that is how we are already handling things? What does WUCIOA say about this issue, or is it silent? Does WUCIOA force things to be this way without having to waste time and money on an amendment? If our declaration is essentially repealed by WUCIOA on January 1st, 2028, does anything at all survive? So, Lisa, if you don't mind, I'm going to jump on a soapbox here.
Go for it. I was just going to say, this is yours, all yours.
Yeah, I just did a presentation on this at the WSCAI annual conference regarding deductible and damage shifting. If it doesn't exist in your documents currently, you cannot do it. There is nothing in statute that allows the association to shift costs of damage to owners unless it is already contained in your governing documents. None of the statutes actually require owners to carry insurance, personal insurance over their unit. So it doesn't matter that this is what you've always done. If it's not in your governing documents, you can't do it. If an owner complies and does it and just pays, that's a windfall to the association, but you cannot count on that because insurance companies, especially the HO6 companies and the association's insurance, are now looking at the governing documents to see what the governing documents say because that's what controls. So if it's not in your governing documents, it doesn't exist. Damage is different from maintenance. So if you're relying on the maintenance section that an owner is responsible to maintain, repair, replace certain components like hot water heaters, dishwashers, washers, dryers, etc., that's that component. That is not damage. Damage is handled later in the declaration. You usually have a specific section on damage, and the vast majority of them still state that the association is responsible for all damage, no matter where it's located or what caused it. So unless you've updated and amended your governing documents to include deductible shifting or damage shifting, it's not there. WUCIOA does allow some damage and deductible shifting. This is found in 6490-480, but it says as found in the governing documents, or as I can't remember the exact term, but as it requires the language to already be in your governing documents to do it. It doesn't allow it otherwise. So unless it's in your governing documents, you can't do it. Your declaration is not repealed by WUCIOA. No declaration is repealed by WUCIOA or any of the governing statutes. What WUCIOA does is some sections it changes what you can and can't do. Other sections is as provided in the declaration or as provided in the governing documents. So as a board or as a homeowner, you have to know where the statute says you can do something, where the statute says you can't do something, whether the statute overrides what your governing documents say, or what language is required to be in your governing documents to get that particular provision of WUCIOA. If you have a question on any of this, contact your association attorney. They're the best one to help you. But unless it's in your governing documents, you can't do deductible or damage shifting. And we have a saying in our office, you have to change your practice to fit your documents or change your documents to fit your practice. Because prior practice, if it violates statute and violates your governing documents, there's no underlying authority. Doesn't matter that you've been doing it this way for 50 years, it's wrong and unenforceable. So, Lisa, did you have anything to add to that?
Nope.
Okay, off my soapbox. For now, anyway.
Although I will say that to Jennifer's point about whether something's collectible or not against an owner, that often does come to me. And I will talk to Jennifer and say, this association says that this owner owes this because of some damage or some repair. And sometimes I have to go back to the association and say, they don't. So this is definitely an important topic, and it's definitely something if you have questions about the way you're handling damages due to incidents in your community, make sure you talk to your association counsel before the board or the association relies on the fact that they think money's coming back into them from an owner for something when your documents may not support that.
What was it, 2 weeks ago, last week? I don't remember if it was you or Valerie or Tima, but I got a question, is this accessible? And the answer was no.
Yeah, it does happen. More than
It
we'd
happens
like, believe me.
frequently.
We'd love
And
to
as
help
I
you make
said,
that not happen.
yeah, it's a topic that I just presented on a WSCAI. So yeah, this is one of my soapbox issues just because I see it so often. So if you have a question about whether or not you can assess something, contact your association attorney. As a manager, please do not make an assumption and then 6 months, 8 months down the road, it has to go to the association attorney for collections and find out that you're wrong. This is something that is very fact specific, very specific to a particular set of governing documents. So there's no wiggle room here. Please double check with an attorney before you try to assess something like that. So we have 3 minutes. I think we can handle this next question pretty quickly.
Okay.
We recently had an owner elected to the board that is not in good standing. Our management company did not vet this owner prior to the election. The board will be discussing this at the next board meeting and vote whether the owner should remain on the board. Should this be done in executive session since the owner is not in good standing? So I'm going to take one quick assumption here. Unless the declaration or bylaws define good standing and whether or not someone can serve on the board if they're not in good standing, if you don't have that specific language in the governing documents, it doesn't matter. They could be 3 years in arrears, have never paid a cent in 3 years. If your governing documents do not state that an owner who is delinquent cannot serve on the board, they can still serve on the board. And then
I will say that if you're looking for what can be discussed in executive session, if to Jennifer's point, you are able to have this conversation and you are able to vet a board member for good standing. Look at 6490-445. I think it's subsection 2. It gives you a list of things you can discuss in executive session. It might be that you can discuss this in executive session because it might fall under the kind of private information about an owner not to be disclosed to the public. But big caveat, but any vote that the board needs to make does not happen in executive session. So keep that in mind. That's for anything we're talking about or anything any board is talking about. You can have discussions about things that may be appropriate in executive session, but you cannot vote in executive session. And we come across that a lot with collections issues. It might be that you need to identify a unit by an account number or something else if you're concerned about disclosing that information, but you do need to vote on in the general session minutes in front of everybody. Anything you
that
wanted to
and
add?
again, the governing documents have to define what is good
That's right.
standing because we've had board members who are in a lawsuit against the association run and maybe get elected, maybe not, but unless there's something in the governing documents that prevents an owner from running if they have a lawsuit, delinquent, what have you, continuing violations, they can still run. They can do anything any other association owner can do. It has to be in the declaration or bylaws. And also, we have this question came up a few weeks ago. We had a community that the board wanted to uh, basically put in a rule that board members could not be delinquent. 6490, 410, I believe, sub 1. And the other statutes, 6434, and that one applies to old act condos as well. And then it's also in 6438. The board is prohibited from determining the terms of board members, the qualities, or I can't remember the exact term off the top of my head, but the association as a whole has to vote on qualifications for board members. It cannot be the board just decides this is what is a qualification to be on the board and put it in the rules. It has to be in the bylaws or declaration, and it has to have ownership approval. Lisa, did you have anything more to add to that?
I don't. I think it looks like it's 11:01, so I think we are done. Thank you so much, everyone, for joining us today, and we will see, some of us will see you next week. Thanks again.
Thank you, everyone.
Bye.